I never thought a plastic slide and some sidewalk chalk could land me in front of a judge. But here I was, standing in a courtroom on a Tuesday morning because my Homeowners Association had lost their collective minds. My name is Keith Quinlan, and I am a 34-year-old software engineer living in Riverside, California. My wife Jennifer and I had purchased our 3-bedroom home in the Meadowbrook community about 2 years ago, thinking we had found the perfect place to raise our 2 kids, Emma, who was 5, and Lucas, who was 3. The neighborhood seemed ideal at first, with its manicured lawns, friendly neighbors, and a community pool we could use during the scorching summer months. What we did not know was that the HOA president, a woman named Patricia Hendricks, had recently taken over and was on a mission to make everyone's life miserable in the name of property values. It started on a humid Saturday afternoon in June. I was inside working on a project deadline when Jennifer came rushing through the front door, her face flushed with anger. She was holding a bright orange envelope, the kind that screams official business, and she slapped it down on the kitchen counter hard enough to make our coffee mugs rattle. "You need to read this," she said, her voice tight with frustration. I picked up the envelope and pulled out the letter inside. The Meadowbrook Community Homeowners Association letterhead sat at the top, looking far more official than it had any right to be. As I read through the contents, my blood pressure started climbing. The letter stated that we were in violation of Section 4.7 of the HOA bylaws regarding front yard aesthetics, and that we had accumulated $300 in fines. $300. For what exactly? "Keep reading," Jennifer said, crossing her arms. According to the letter, our violations included having children's toys visible in the front yard during non-play hours, sidewalk chalk drawings on our driveway, and a small inflatable pool that had been set up for exactly 4 hours the previous weekend. The letter went on to explain that these items created an eyesore and diminished the community's property values. We had 72 hours to remove all offending items and pay the fine, or additional penalties would be assessed at $50 per day. "This is insane," I said, reading through it again to make sure I had not misunderstood. "Emma's slide has been in the front yard for 2 weeks. Nobody said anything until now." "That's because Patricia just became president last month," Jennifer explained. I ran into Susan from down the street at the grocery store yesterday. She said Patricia has been sending these letters to half the neighborhood. The Johnsons got fined for having their trash cans visible from the street on a non-collection day. The trash truck had not even come yet. I looked out our front window at the offending items. Emma's little pink and purple slide sat on the grass near the walkway. A bucket of sidewalk chalk rested on the porch steps. The inflatable pool had been deflated and put away days ago, but apparently someone had photographed it and reported it to the HOA. The whole thing felt like a fever dream. "We are not paying this," I said firmly. "This is ridiculous. Kids live here. They play outside." "That's what normal families do." Jennifer nodded in agreement. "I already looked up the bylaws online. That Section 4.7 she mentioned talks about abandoned property and junk vehicles, not kids' toys. She is twisting the rules." That evening, I drafted a response letter to the HOA explaining that we would not be paying the fine, and that we believed the interpretation of the bylaws was incorrect. I kept it professional and cited the actual language of Section 4.7, which clearly referred to derelict vehicles, construction materials, and trash, not children's recreational equipment. I printed it out, signed it, and dropped it in the mail the next morning, feeling confident that this would be the end of it. I was wrong. 4 days later, another orange envelope appeared in our mailbox. This time, The fine had increased to $450. Patricia had added late fees and doubled down on her interpretation of the rules. The letter also included a grainy photograph of our front yard, clearly taken from the street, with red circles drawn around Emma's slide and the chalk bucket. At the bottom, in bold letters, it stated that if we did not comply within 5 days, the matter would be turned over to the HOA's legal counsel, and a lien could be placed on our property. "A lien," Jennifer said when I showed her the letter. "She is threatening to put a lien on our house over a toy slide." I called an emergency meeting with our neighbors who had also received similar letters. 7 families showed up at our house that Sunday afternoon, all holding their own orange envelopes. The Johnsons had been fined for their trash cans. The Rodriguezes had been fined for having a garden hose visible from the street. The Chens had been fined for their daughter's bicycle being parked on their front lawn. Every violation was petty, and every fine was substantial. "This is harassment," said Marcus Johnson, a tall man in his 40s who worked as a contractor. "I have lived in this neighborhood for 8 years. We have never had problems like this before." "Patricia is on some kind of power trip," added Linda Rodriguez. "My mother-in-law visited last month and parked her car on the street overnight. I got a $100 fine for that. The bylaws say nothing about visitor parking restrictions." We spent 2 hours sharing stories and comparing notes. It became clear that Patricia had taken her role as HOA president and turned it into a personal fiefdom. She was interpreting every rule in the strictest possible way and inventing violations where none existed. Several neighbors mentioned that Patricia had recently retired from her job as a bank manager and seemed to have devoted all her free time to policing the neighborhood. "We should fight this together," I suggested. "If we all push back at once, maybe the HOA board will realize this has gone too far." Everyone agreed. We drafted a joint letter to the HOA board requesting an emergency meeting to discuss the recent fines and Patricia's enforcement policies. We collected signatures from 15 families and submitted it the next day. According to the HOA bylaws, the board was required to hold a special meeting within 14 days if requested by 10 or more homeowners in good standing. The meeting was scheduled for a Thursday evening 2 weeks later at the community center. Jennifer and I arrived early, along with most of our neighbors who had signed the petition. The community center was a small building near the pool, with a meeting room that could hold about 50 people. By the time the meeting started, nearly 40 homeowners had packed into the space, many of them holding their own orange envelopes. Patricia Hendricks sat at a table at the front of the room, flanked by 2 other board members, Thomas Webb and Margaret Sullivan. Patricia was exactly what you would picture when you imagined an overbearing HOA president. She was in her early 60s with short blonde hair styled in a severe bob, wearing a navy blazer that looked like it cost more than my car payment. She had the kind of pinched expression that suggested she found everything around her vaguely distasteful. "This meeting will come to order," Patricia announced, banging a gavel on the table with unnecessary force. "I understand that several homeowners have concerns about recent enforcement actions. However, I want to make it clear that this board has a fiduciary duty to maintain property values, and that requires strict adherence to our community standards." Marcus Johnson stood up. "Patricia, these fines are unreasonable. You are charging people hundreds of dollars for having normal household items visible from the street. Kids' toys, garden hoses, bicycles. These are not violations. The bylaws clearly state that front yards must be maintained in a manner consistent with community aesthetics," Patricia replied coldly. "Toys and equipment create visual clutter. If we allow one family to leave items out, Soon the entire neighborhood will look like a junkyard. That is a ridiculous slippery slope argument, I said, standing up. My daughter's slide is not junk. It is a toy that she uses every day. We bring it inside at night, but it sits outside during the day because that is when she plays. That is normal. Patricia fixed me with a cold stare. Mr. Quinlan, the rules apply to everyone equally. If you do not like the rules, perhaps you should have read the bylaws more carefully before purchasing your home. I did read the bylaws, I shot back. Section 4.7 does not say anything about children's toys. You are making this up as you go along. The room erupted in agreement, with multiple neighbors speaking up at once. Patricia banged her gavel again, her face reddening. Order! I will have order in this meeting. Thomas Webb, one of the other board members, cleared his throat. He was an older gentleman with gray hair and glasses, and he looked distinctly uncomfortable with the situation. Patricia, perhaps we could discuss a more reasonable approach to enforcement. These fines do seem quite high for minor infractions. Are you questioning my judgment? Patricia snapped at him. I am suggesting that we might be overstepping our authority, Thomas said carefully. Several of these violations are questionable at best. I do not think the bylaws were intended to prohibit children from playing in their own yards. The bylaws say what they say, Patricia insisted. And as president, it is my responsibility to enforce them. If people do not want to pay fines, they should follow the rules. Margaret Sullivan, the third board member, had been silent throughout the meeting, but she finally spoke up. I have to agree with Thomas. These enforcement actions seem excessive. Maybe we should table the existing fines and revise our enforcement guidelines before proceeding. Patricia looked betrayed. You are both undermining the integrity of this board. Fine. Let's put it to a vote. All in favor of suspending the current fines and revising enforcement guidelines. Thomas and Margaret both raised their hands. Patricia glared at them, but was forced to acknowledge the majority vote. Fine. The fines are temporarily suspended pending review. But make no mistake, this board will continue to enforce community standards. Meeting adjourned. She slammed the gavel down and stormed out of the room without another word. The rest of us sat there in stunned silence for a moment before people started talking excitedly. We had won a small victory, but something about Patricia's reaction made me uneasy. This did not feel like the end of the conflict. Over the next week, things were quiet. The orange envelopes stopped appearing in mailboxes, and people started to relax. Jennifer and I kept Emma's slide in the front yard during the day, and nobody said anything. I thought maybe Patricia had gotten the message and would back off. Then I came home from work on a Tuesday and found something shocking. Our slide was gone. Not just moved, but completely missing. I walked around the entire yard, thinking maybe the wind had blown it away, but there was no sign of it anywhere. The chalk bucket was also missing from the porch. Did you move Emma's slide? I asked Jennifer when I went inside. No. It was there this morning when we left for school, she said, looking confused. We searched everywhere. I checked with our immediate neighbors to see if maybe Emma had left it at their houses, but nobody had seen it. That is when I noticed the tire tracks in our grass near where the slide had been. Someone had driven onto our lawn and taken it. Call the police, Jennifer said, pulling out her phone. Someone stole our stuff. A police officer arrived about 30 minutes later. Officer David Chen took our statement and photographed the tire tracks in the grass. He seemed skeptical that someone would steal a child's slide, but he filed a report anyway. To be honest, this seems pretty targeted, he said. Random thieves do not usually bother with used toys. Is there anyone who might have a grudge against you? I explained the situation with the HOA and Patricia. Officer Chen wrote down her name and information, but he told us there was not much he could do without evidence. He suggested we install security cameras, which I immediately ordered online that evening. The cameras arrived 2 days later, and I spent Saturday afternoon installing them around our property. I put one covering the front yard, one on the porch, and one on the driveway. They were wireless and connected to an app on my phone, so I could review footage from anywhere. I felt a little paranoid setting them up, but recent events had made it clear that something strange was happening in our neighborhood. The cameras proved their worth sooner than I expected. The following Wednesday, I got a motion alert on my phone while I was at work. I pulled up the app and watched in disbelief as a white SUV pulled up to our house at 2 in the afternoon. A woman got out, walked onto our lawn, and picked up Emma's bucket of sidewalk chalk that Jennifer had set out that morning. The woman looked around nervously, then got back in her SUV and drove away. I did not recognize the woman, but the license plate was clearly visible in the footage. I immediately called the police and sent them the video. Officer Chen called me back within an hour. "Mr. Quinlan, we ran that plate. The vehicle is registered to Patricia Hendricks. Is that your HOA president?" My jaw dropped. "Yes, that is her, but the woman in the video is not Patricia. She is younger, maybe in her 30s. Could be a relative or friend," Officer Chen said. "Either way, this is theft. We will pay Miss Hendricks a visit and ask her some questions. I'll keep you updated." That evening, Officer Chen called me back with an update. The woman in the video was Patricia's daughter, Nicole Hendricks, who lived in Morno Valley about 20 minutes away. When confronted with the video evidence, Nicole initially denied everything, but eventually admitted that her mother had asked her to remove items from various properties in the neighborhood. She claimed she was just helping her mother enforce HOA rules and did not think she was doing anything wrong. We explained to her that taking property from someone's yard without permission is theft, regardless of her mother's position in the HOA, Officer Chen explained. She returned the items she still had in her possession, including your slide and chalk. She took them to her mother's house, and we retrieved them from there. Miss Hendricks Sr. was not happy about our visit. "Is Nicole being charged with anything?" I asked. "That is up to you," Officer Chen said. "You are the victim here. We can charge her with petty theft if you want to press charges." I thought about it for a moment. Part of me wanted to pursue charges just to make a point, but another part of me worried about escalating the situation even further. "Let me talk to my wife and I'll let you know," I said. Jennifer and I discussed it that night after the kids were in bed. She was angrier than I had ever seen her. "Press charges," she said firmly. "Patricia sent her daughter to steal from us and our neighbors. That is beyond HOA overreach. That is criminal behavior. If we do not hold them accountable, what's next?" She was right. The next morning, I called Officer Chen and told him we wanted to press charges against Nicole Hendricks. He said he would forward the case to the district attorney's office for review. 2 days later, I received an orange envelope in the mail. My heart sank before I even opened it. Inside was a letter from Patricia stating that we were being fined $500 for installing security cameras on our property without HOA approval. According to the letter, Section 6.2 of the bylaws required homeowners to submit applications for any exterior modifications, including security equipment, and obtain approval before installation. I was so angry I could barely see straight. Patricia was retaliating against us for involving the police. I immediately pulled up the bylaws online and read Section 6.2 in its entirety. The section did require approval for certain exterior modifications, but it specifically listed things like additions, fences, sheds, and satellite dishes. Security cameras were not mentioned anywhere in the text. I printed out the relevant pages and wrote another response letter, this time with a warning. I stated clearly that Patricia's interpretation of the bylaws was incorrect, that her retaliation for our lawful police report was inappropriate, and that if she continued this harassment, we would be forced to take legal action. I sent the letter certified mail so I would have proof of delivery. The certified letter came back signed a week later, but Patricia's response was not what I expected. Instead of backing down, she doubled down. Another letter arrived stating that the HOA would be pursuing legal action to collect all outstanding fines, which now totaled over $1,000 when you included all the various penalties and fees she had invented. The letter stated that we had 30 days to pay or the HOA would file a lawsuit. "She is insane," Jennifer said, staring at the letter in disbelief. "She actually thinks she is going to win this." I started researching lawyers that evening. I had never sued anyone or been sued before, and the whole process felt overwhelming. I found several attorneys in Riverside who specialized in HOA disputes, and I started calling them the next day during my lunch break. The third attorney I spoke with was a woman named Rebecca Torres. She had been practicing law for 15 years and had handled dozens of HOA cases. When I explained our situation, she laughed, which caught me off guard. "I am sorry," she said, still chuckling. "I am not laughing at you. I am laughing because this is one of the most blatant cases of HOA overreach I have heard in years. Patricia Hendricks is going to regret this." "So you think we have a case?" I asked. "Mr. Quinlan, you have more than a case. Based on what you have told me, your HOA president has misinterpreted the bylaws, harassed multiple homeowners, orchestrated the theft of your property, retaliated against you for reporting said theft, and is now threatening to sue you over violations that do not actually exist." "Yes, I think you have a case." We scheduled a meeting for the following day. Rebecca's office was in downtown Riverside, in a modern building with glass walls and sleek furniture. She was in her early 40s with dark hair pulled back in a bun, and she had the kind of confident demeanor that immediately put me at ease. I brought Jennifer with me to the meeting, along with all the letters we had received from the HOA, the police reports about the theft, the security camera footage, and printouts of the relevant sections of the bylaws. Rebecca spent over an hour reviewing everything, taking notes on a yellow legal pad. "Here is my assessment," she said finally. "Patricia has violated California Civil Code in multiple ways. First, the HOA's bylaws clearly do not prohibit children's toys or security cameras in the manner she claims. Second, her enforcement actions appear to be arbitrary and discriminatory. Third, and most importantly, she coordinated the theft of your property and then retaliated against you for reporting it to the police. That last part is particularly damning." "What should we do?" Jennifer asked. "Wait for them to sue you," Rebecca said with a slight smile. "I know that sounds counterintuitive, but if Patricia actually files a lawsuit over these bogus fines, we can countersue for harassment, wrongful fees, and emotional distress. The HOA's insurance will probably settle the moment they see the evidence. Plus, the publicity from a case like this could force the other board members to remove Patricia from her position." "What if they do not sue?" I asked. "What if she just keeps sending threatening letters?" "Then we sue them first for harassment and theft," Rebecca said. "But I think Patricia's ego is going to push her to follow through. People like her do not back down easily. She has convinced herself that she is right, and she will want her day in court." Rebecca was right. 4 weeks later, I was served with legal papers. The Meadowbrook Community Homeowners Association was suing Keith Quinlan and Jennifer Quinlan for $1,200 in unpaid fines, plus legal fees and court costs. The lawsuit was filed in Riverside County Superior Court, and we were required to respond within 30 days. I immediately sent the papers to Rebecca, who seemed positively delighted by the development. "Perfect," she said when I called her. "Now we can really go after them." Rebecca filed our response to the lawsuit, which included a detailed defense and a counterclaim against the HOA for wrongful fines, harassment, and damages. Our counterclaim sought $3,000 in damages, plus attorney's fees. We also filed a separate motion to have Patricia Hendricks removed from the HOA board pending the outcome of the case, citing her illegal actions and conflicts of interest. The legal process moved slowly. Months went by with various filings, motions, and discovery requests. Rebecca requested all HOA board meeting minutes for the past year, all enforcement actions taken under Patricia's leadership, and all financial records related to fines and legal expenses. The HOA's attorney, a man named Richard Sampson, tried to fight some of the discovery requests, but the judge ordered them to comply. What we found in those documents was shocking. Patricia had issued over $60,000 in fines to homeowners in the 6 months since she became president. The previous president had issued less than $5,000 in fines during his entire 3-year tenure. It became obvious that Patricia was using her position to bully the community and generate revenue for the HOA, possibly to fund her own pet projects. We also discovered that Patricia had used HOA funds to hire her brother-in-law's law firm to pursue the lawsuit against us, which was a clear conflict of interest. Richard Sampson worked at Henderson and Associates, and Edward Henderson was married to Patricia's sister. None of this had been disclosed to the HOA board or the homeowners. Rebecca filed an amended counterclaim, adding allegations of self-dealing and breach of fiduciary duty. The case was getting bigger and more complicated, and I worried about the legal fees piling up. Rebecca assured me that when we won, the HOA would be responsible for paying our attorney's fees, which were already approaching $10,000. Meanwhile, life in the neighborhood had become tense. Patricia's supporters, a small group of older homeowners who liked the idea of strict rules, started avoiding us at community events. Other families who had received fines began reaching out, asking if they could join our lawsuit. Rebecca eventually filed a motion to have the case certified as a class action, representing all homeowners who had been fined under Patricia's enforcement regime. The class action motion changed everything. Suddenly, the HOA was facing potential liability not just to us, but to dozens of families. The HOA's insurance company got involved and started pressuring the board to settle. Thomas Webb and Margaret Sullivan, the 2 board members who had voted against Patricia at that contentious meeting, began distancing themselves from her publicly. Patricia, however, refused to back down. At a board meeting in February, 8 months after this whole mess started, she gave a defiant speech about how she was protecting the community from chaos and lawlessness. Several homeowners walked out in protest. A petition started circulating to remove her from the board, and it quickly gathered signatures from over 60% of the homeowners. The trial date was set for late March. Rebecca spent weeks preparing, interviewing witnesses, and organizing evidence. She was confident we would win, but I was nervous. I had never been involved in a lawsuit before, and the thought of standing up in court and testifying made my stomach churn. The night before the trial, I barely slept. Jennifer and I went over our testimony one more time, making sure we remembered all the important dates and details. Emma asked why we were so stressed, and we explained in simple terms that we were going to court to talk to a judge about the neighborhood rules. She nodded solemnly and told me she hoped we won, which made me smile despite my anxiety. The trial was held in Riverside County Superior Court, a large modern building downtown. We arrived early and met Rebecca in the lobby. She looked professional and confident in a charcoal gray suit, carrying a briefcase stuffed with documents. "Remember," she said as we walked to the courtroom, "stay calm, tell the truth, and do not let them rattle you. This is an open and shut case. The evidence is on our side." The courtroom was smaller than I expected, with wooden benches and a raised platform where the judge sat. Patricia was already there with Richard Sampson, her brother-in-law's law partner. She did not look at us when we walked in. The judge, a woman named Honorable Linda Martinez, entered the courtroom, and we all stood. She was in her 50s with dark hair touched with gray, and she had a no-nonsense expression that suggested she did not tolerate foolishness in her courtroom. "Please be seated," Judge Martinez said. "We are here for the matter of Meadowbrook Community Homeowners Association versus Quinlan, case number RIC 1,904,567. Are both parties ready to proceed?" Rebecca and Richard Sampson both indicated they were ready. Judge Martinez looked down at the file in front of her, flipping through pages with a slight frown. "Before we begin with opening statements, I want to note that I have reviewed the pleadings in this case, and I have some concerns about the HOA's claims. Mr. Sampson, this lawsuit alleges that the defendants owe fines for having children's toys in their yard and security cameras on their house. Is that correct?" Richard Sampson stood up. "Yes, Your Honor. The defendants violated clearly established community standards as outlined in the HOA bylaws." "I read those bylaws," Judge Martinez said dryly. "Where exactly do they prohibit children's toys?" Richard Sampson looked flustered. "Section 4.7 prohibits items that create visual blight or diminish property values, Your Honor. Section 4.7 refers to abandoned vehicles and construction debris," the judge said, her tone sharpening. "I see nothing about toys. What about the security cameras?" "Section 6.2 requires approval for exterior modifications," Richard said. "Section 6.2 specifically lists additions, fences, and satellite dishes," Judge Martinez said. "Security cameras are not mentioned." "Mr. Sampson, are you aware that there is a criminal case pending against the HOA president's daughter for stealing property from the defendant's yard?" "That matter is unrelated to this lawsuit, Your Honor," Richard said weakly. "It seems very related to me," the judge said. "The HOA president allegedly sent someone to steal the very items she claimed were violations, then retaliated against the defendants for reporting the theft. That suggests this lawsuit is not about legitimate rule enforcement, but about personal vendetta." I glanced at Rebecca, who was trying hard not to smile. Patricia, on the other hand, looked like she wanted to crawl under the table. "Miss Torres, do you have anything to add?" Judge Martinez asked. Rebecca stood up. "Your Honor, the defendants are prepared to present extensive evidence showing that the HOA president has engaged in a pattern of harassment and misinterpretation of the bylaws. We believe this lawsuit is frivolous and should be dismissed with prejudice. Furthermore, we ask that the court award attorneys' fees and sanctions." Judge Martinez nodded slowly. "Mr. Sampson, I am inclined to agree with Miss Torres. This lawsuit appears to be completely without merit. The bylaws do not support the HOA's interpretation, and the circumstances surrounding this case suggest abuse of authority. I am going to give you one chance to withdraw this lawsuit and avoid sanctions. What say you?" Richard Sampson looked at Patricia, who was shaking her head vigorously. He turned back to the judge. Your Honor, we believe our interpretation of the bylaws is correct, and we ask the court to rule on the merits. Very well, Judge Martinez said, and her expression made it clear that this was not going to end well for the HOA. We will proceed with opening statements. The trial lasted 3 days. Rebecca presented our case methodically, showing the judge every letter we had received, the security camera footage of Nicole Hendricks stealing our property, the police reports, and the financial records showing Patricia's excessive fine regime. She called several neighbors to testify about their own experiences with Patricia's enforcement actions. Marcus Johnson testified about his trash can fine. Linda Rodriguez testified about her mother-in-law's parking ticket. A woman named Sarah Chen broke down in tears on the stand, describing how Patricia had fined her $300 because her daughter left a bicycle on their front lawn overnight. Rebecca also called Thomas Webb, one of the other board members, who testified that Patricia had acted unilaterally on most enforcement decisions without consulting the rest of the board. He stated that he and Margaret Sullivan had tried to rein in her behavior, but that Patricia had threatened to sue them personally if they interfered with her authority as president. When it was the HOA's turn to present their case, Richard Sampson called Patricia to the stand. She was dressed in another expensive-looking suit, and she carried herself with an air of superiority that was almost impressive given how badly things were going for her. Miss Hendricks, Richard said, can you explain to the court why you believed it was necessary to fine the defendants for having toys in their yard? The bylaws are clear, Patricia said coldly. Front yards must be maintained in a manner consistent with community standards. Toys create clutter and reduce property values. As president, it is my duty to enforce these standards. And you believe the bylaws support your interpretation? Richard asked. Absolutely, Patricia said. Rebecca stood up for cross-examination, and I could tell she was looking forward to this. Miss Hendricks, you testified that toys reduce property values. Do you have any evidence to support that claim? Patricia hesitated. It is common sense. So you have no appraisals, no studies, no data whatsoever showing that a child's slide reduces property values. I do not need data, Patricia said defensively. Anyone can see that clutter is unattractive. Miss Hendricks, are there children living in the Meadowbrook community? Rebecca asked. Yes, several families have children. And where do you expect those children to play? Rebecca asked. In their backyards or at the community park, Patricia said. What if a family does not have a backyard? Rebecca pressed. What if they only have a small front yard? Then they should find a different neighborhood, Patricia said sharply. The judge's eyebrows shot up at that comment, and Rebecca smiled. You think families with children should leave the neighborhood if they cannot meet your standards? I think people should follow the rules, Patricia said. Rebecca pulled out a photograph. Miss Hendricks, do you recognize this item? The photograph showed a decorative garden gnome sitting in someone's front yard. Patricia looked at it and nodded. Yes, that is the Johnson family's garden gnome. Have you ever fined the Johnsons for having this gnome in their front yard? Rebecca asked. No, Patricia said. Garden ornaments are acceptable. But a child's toy is not, Rebecca said. Can you explain the difference? Garden ornaments are tasteful decorations, Patricia said. Toys are clutter. I see, Rebecca said. She pulled out another photograph. Miss Hendricks, do you recognize this basketball hoop? The photo showed a portable basketball hoop in someone's driveway. Patricia nodded. Yes, that belongs to the Martinez family. Have you ever fined them for it? No. Why not? Rebecca asked. Is a basketball hoop not a toy? Basketball is a sport, Patricia said stiffly. It is different. Different how? Rebecca pressed. Both are recreational equipment used by children. Why is one acceptable and the other is not? Patricia did not have a good answer. She stammered for a moment before saying, I use my discretion as president to determine what violates community standards. So your enforcement is arbitrary and based on your personal preferences, not on any objective standard in the bylaws, Rebecca said. That is not what I said, Patricia snapped. Rebecca pulled out another document. Miss Hendricks, do you recognize this email? She showed it to Patricia, who paled slightly. I may have sent that, she admitted. This is an email you sent to your daughter Nicole in August of last year, correct? Rebecca said, Please read the highlighted portion for the court. Patricia reluctantly read from the email. Nicole, I need you to help me remove some items from properties in the neighborhood. The homeowners are being stubborn about following the rules, so we need to take matters into our own hands. Take matters into your own hands, Rebecca repeated. Miss Hendricks, were you instructing your daughter to steal property from homeowners? I was asking her to help enforce the rules, Patricia said defensively. By taking property that did not belong to her without the owner's permission, Rebecca said. Miss Hendricks, that is called theft. I was protecting the community, Patricia insisted, her voice rising. Your daughter was charged with petty theft for taking my client's property, Rebecca said. She pled guilty last month and received probation. Are you aware of that? Patricia said nothing, her face red with anger and humiliation. No further questions, Rebecca said, sitting down. The rest of the HOA's case fell apart just as dramatically. Richard Sampson tried to call an appraiser to testify about property values, but the appraiser admitted under cross-examination that he had done no specific analysis of the Meadowbrook community and could not say whether toys affected values one way or another. Richard tried to call Margaret Sullivan to support Patricia's actions, but Margaret refused, stating that she did not agree with how Patricia had handled things. After closing arguments on the third day, Judge Martinez said she would issue a ruling within 48 hours. Rebecca told us that was a good sign, because judges usually only moved that quickly when they had already made up their minds. True to her word, Judge Martinez issued her ruling 2 days later. Jennifer and I drove back to the courthouse to hear it in person. The courtroom was packed with homeowners from our neighborhood who had followed the case closely. Judge Martinez entered and we all stood. She took her seat and opened a folder containing her written ruling. I have carefully considered all the evidence and testimony in this case, she began. The court finds that the plaintiff, Meadowbrook Community Homeowners Association, has completely failed to demonstrate that the defendants violated any legitimate provision of the HOA bylaws. The association's interpretation of sections 4.7 and 6.2 is tortured at best and completely unsupported by the plain language of those provisions. Patricia sat rigid in her chair, staring straight ahead. Furthermore, Judge Martinez continued, the court is deeply troubled by the conduct of the HOA president, Miss Patricia Hendricks. The evidence shows that she orchestrated the theft of the defendant's property, retaliated against them for reporting that theft, and engaged in a pattern of arbitrary and capricious enforcement of HOA rules. Her testimony that families with children should leave the neighborhood if they cannot meet her personal standards is particularly disturbing. The judge looked directly at Patricia. Miss Hendricks, your behavior has been nothing short of abusive. You have taken a position of trust within your community and used it to harass your neighbors over trivial matters. The idea that a child's toy constitutes a violation worthy of hundreds of dollars in fines is ridiculous. I saw several people in the courtroom nodding in agreement. The court hereby dismisses the HOA's lawsuit with prejudice, Judge Martinez said firmly. Not only is this case without merit, but it should never have been filed in the first place. The court finds that this lawsuit was brought in bad faith for the purpose of harassment. She flipped to another page. The court grants the defendant's counterclaim in its entirety. The HOA is ordered to pay the defendants $3,000 in damages, plus all attorney's fees and costs incurred in defending this action. Based on the fee statement submitted, that amount is $14,600. I heard Jennifer gasp beside me. We were going to recover all our legal fees and then some. Additionally, Judge Martinez said, the court is imposing sanctions of $5,000 against the HOA for bringing a frivolous lawsuit. That money will be donated to a local children's charity selected by the defendants. Judge Martinez was not done. The court also finds that Ms. Hendricks's conduct violated California Civil Code Section 5850, which prohibits HOA directors from engaging in conduct that is unreasonable, arbitrary, or capricious. The court recommends that the HOA board consider whether Ms. Hendricks should continue to serve in her current capacity. Patricia finally reacted, half rising from her chair. Your Honor, this is outrageous. Sit down, Miss Hendricks, Judge Martinez said sharply. You should consider yourself fortunate that criminal charges are not being pursued against you personally for your role in the theft. I strongly suggest you reflect on your actions and consider whether you are fit to lead any organization. She banged her gavel. The court's ruling is final. This case is closed. The courtroom erupted in quiet conversation as Judge Martinez left the bench. I turned to Jennifer and we hugged each other tightly. Rebecca came over and shook our hands, grinning broadly. That was even better than I hoped, she said. Judge Martinez completely eviscerated them. Patricia stormed out of the courtroom without speaking to anyone, Richard Sampson hurrying after her. Several of our neighbors came over to congratulate us and ask about the possibility of getting their own fines refunded. We can definitely pursue that, Rebecca said. Now that the judge has ruled that Patricia's enforcement was arbitrary and capricious, all the fines issued under her authority are probably invalid. I will file a motion to have them all vacated. Over the next few weeks, the fallout from the trial spread through the neighborhood. The local newspaper ran a story about the case with the headline, "Judge Calls HOA Fines Ridiculous in Toy Dispute." The article quoted extensively from Judge Martinez's ruling and included interviews with several homeowners about their experiences with Patricia's enforcement regime. The publicity was the final straw for the HOA board. 2 weeks after the trial, Thomas Webb called an emergency board meeting and moved to remove Patricia as president for conduct unbecoming of an officer. Margaret Sullivan seconded the motion, and it passed 2-1, with only Patricia voting against it. Patricia was given the option to resign from the board entirely or be removed through a homeowner vote. She chose to resign. Rebecca filed the motion to vacate all fines issued under Patricia's authority, and the new interim board president, Thomas Webb, actually supported it. He testified at a hearing that the board had never properly authorized most of the fines, and that Patricia had acted outside her authority. The judge granted the motion, wiping out over $60,000 in fines that had been levied against various homeowners. The HOA's insurance company paid our damages and attorney's fees within 30 days as ordered by the court. Jennifer and I used some of that money to take the kids on a long-delayed vacation to San Diego. The rest went into savings, though we did splurge on a new and bigger slide for Emma and a swing set for Lucas. Nicole Hendricks, Patricia's daughter, completed her probation for the theft charge without incident. She wrote us a letter of apology, which seemed sincere. She explained that her mother had convinced her that what they were doing was legal and justified, and she had not questioned it until the police showed up. I appreciated the apology, though I never responded to it. Patricia herself disappeared from neighborhood events entirely. We would occasionally see her coming or going from her house, but she never acknowledged us or anyone else. Rumors circulated that she was planning to sell her house and move away, but as of several months after the trial, she was still living there. The new HOA board, led by Thomas Webb as president, adopted a completely different approach to community management. They revised the enforcement guidelines to focus on genuine safety issues and major violations, not petty complaints about toys and garden hoses. They also implemented a new policy requiring board approval before any fine over $100 could be issued, preventing any single person from wielding the kind of power Patricia had abused. Several homeowners who had been active in fighting Patricia's regime ran for board positions in the next election. Marcus Johnson was elected as treasurer, and Linda Rodriguez became the secretary. The community felt different after that, less tense and more friendly. People started actually enjoying living there again, instead of walking on eggshells worried about the next orange envelope. As for our family, things returned to normal remarkably quickly. Emma's slide stayed in the front yard during the day, and nobody ever complained again. Lucas learned to love his new swing set, and on summer afternoons, our front yard was full of kids from the neighborhood playing together. It was exactly what a family neighborhood should be. I installed a small plaque near our front door that said, "Home Sweet Home," with a subheading that made Jennifer laugh every time she saw it. "Ridiculous Toys Welcome." It was my way of remembering that sometimes standing up for common sense and your family is worth the fight, even when it means going to court. The whole experience taught me several important lessons. First, that positions of minor authority can go to people's heads in dangerous ways. Patricia was never a bad person inherently, but giving her unchecked power over the neighborhood brought out the absolute worst in her personality. Second, that community is built on understanding and flexibility, not rigid enforcement of rules for rules' sake. And third, that sometimes you have to push back hard against bullies, even when it is expensive and stressful, because letting them win only encourages more bad behavior. About 6 months after the trial, I was outside on a Saturday morning helping Emma learn to ride her bicycle without training wheels. She was wobbling down the sidewalk with me running beside her, both of us laughing, when a car pulled up. I did not recognize it at first, but then I saw Patricia in the driver's seat. She rolled down her window and I tensed, not sure what to expect, but her expression was different than I had ever seen, softer somehow and less hostile. "I wanted to apologize," she said quietly, "for everything. I got carried away with trying to make the neighborhood perfect, and I hurt a lot of people in the process, especially your family." I was stunned. Emma had stopped her bike and was watching curiously. "I appreciate you saying that," I said carefully. "I am moving at the end of the month," Patricia continued. "Going to live near my sister in Arizona. Fresh start, but I wanted you to know that the judge was right. What I did was ridiculous. I am sorry." She did not wait for a response. She just rolled up her window and drove away. I stood there for a moment processing what had just happened, then turned back to Emma. "Who was that?" she asked. "Just someone saying goodbye," I said. "Come on, let's get you riding this bike." We spent the rest of the morning practicing, and by lunchtime, Emma was riding confidently on her own, her face beaming with pride. Jennifer came out and took pictures, and Lucas clapped enthusiastically from his spot on the front steps. That afternoon, several neighbor kids came over and they all played together in our front yard, the slide and swings getting constant use. I sat on the porch watching them, thinking about everything that had happened over the past year. It had been stressful and expensive and frustrating, but in the end, it had been worth it. Our kids could play in their own yard without fear of harassment. Our community had learned to stand up against petty tyranny. And a judge had put into the official record that sometimes common sense matters more than rigid rules. The orange envelopes never came back. The HOA board, under Thomas's leadership, sent out notices occasionally about genuinely important things like pool maintenance schedules and road repairs. But they were printed on regular white paper and written in friendly, reasonable language. The neighborhood became what it should have been all along, a place where families could live and grow and kids could be kids. Emma's slide stayed in that front yard until she outgrew it 3 years later. When we finally donated it to a local preschool, Jennifer suggested we should keep it as a memento of our legal victory, but I disagreed. The slide had served its purpose, both as a toy and as an unlikely symbol of standing up for what is right. Better to let other kids enjoy it than turn it into a trophy. Sometimes I still think about that day in court when Judge Martinez called the whole situation ridiculous. She was absolutely right, of course. The idea that a toy could be worth thousands of dollars in legal fees and months of stress was absurd. But in a way, it was also important. Because if we had just paid that first fine, Patricia would have kept going and the harassment would have gotten worse. By fighting back, we not only protected ourselves but dozens of other families too. These days when I drive through our neighborhood, I see kids' bikes on lawns, basketball hoops in driveways, and yes, toys scattered across front yards. I see families living their lives without fear of petty enforcement actions. And I see a community that learned to govern itself with reason and compassion instead of rigid authoritarianism. The whole experience made me appreciate our home in a way I had not before. Not just the physical house, though I loved that too, but the idea of home as a place where you should feel safe and free to be yourself. Where your kids can play without someone measuring whether their toys meet some arbitrary aesthetic standard. Where neighbors look out for each other instead of reporting each other for minor infractions. Years later, when Lucas was old enough to understand, I told him the story of the great HOA war over his sister's slide. He thought it was hilarious that adults had spent so much time and money arguing about a toy. He was right, of course. It was hilarious. But it was also necessary, because in the end, this was not really about a slide or sidewalk chalk or security cameras. It was about whether a community would be governed by common sense and mutual respect, or by one person's need for control. And thanks to a judge who was not afraid to call it like she saw it, common sense won. I never framed Judge Martinez's ruling, though Rebecca offered to send me a nice copy suitable for hanging. I did not need a physical reminder of our victory. Every time I looked out my front window and saw kids playing in yards up and down the street, every time I went to an HOA meeting where people treated each other with respect, every time I pulled into my driveway without worrying about what vindictive letter might be waiting in the mailbox, I was reminded that we had fought for something important and won. Patricia did move to Arizona as she said she would. I heard through the neighborhood grapevine that she was living in a retirement community there with very strict HOA rules, which seemed appropriate somehow. I hope she was happy, or at least at peace. Holding grudges never helped anyone. The $5,000 in sanctions that Judge Martinez ordered paid to charity went to the Riverside Children's Foundation, which provides recreational programs for underprivileged kids. Jennifer and I attended the check presentation ceremony, and the foundation director told us the money would be used to buy playground equipment for a community center in a low-income neighborhood. It felt right that Patricia's overreach about toys would ultimately result in more kids getting to play. Our attorney Rebecca became something of a local celebrity in HOA law circles after our case. She told me she got several calls a week from homeowners dealing with similar situations in other communities. She took on as many cases as she could, always with the same philosophy. HOAs serve an important function, but they are meant to maintain communities, not terrorize them. As I write this, it has been nearly 5 years since that first orange envelope appeared in our mailbox. Emma is now 10 and has moved on from slides to soccer and art classes. Lucas is 8 and is obsessed with building elaborate structures with blocks and Legos, which often end up scattered across our front yard before he brings them inside. The new HOA board has never said a word about it. Jennifer and I are still in the same house, and we plan to stay there for many years to come. We have made good friends with many of our neighbors, particularly the ones who went through the fight against Patricia's regime together. There is something bonding about shared adversity, and we all look out for each other now in ways that go beyond just being friendly acquaintances. The legal victory became a template for other homeowners fighting similar battles. Rebecca used our case as a precedent in several subsequent lawsuits, and the judge's language about toys being a normal part of family life has been cited in HOA disputes across California. In a small way, our fight helped change how courts view overzealous HOA enforcement. But the most important outcome was not legal or precedential. It was simply that our kids got to have a normal childhood in their own front yard. Emma and Lucas will probably never fully understand what we went through to protect that simple right, and that is exactly how it should be. Childhood should be about playing and learning and growing, not about adults' petty disputes over aesthetics and property values. Sometimes on summer evenings, I sit on our front porch and watch the neighborhood kids ride bikes and play games in the street while their parents chat on various lawns. I think about how close we came to losing this, to having our community turned into a place where every action was scrutinized and every mistake was punished. And I feel grateful that we fought back, that Judge Martinez saw through the nonsense, and that common sense prevailed. The slide is long gone, donated to that preschool where I hope it brought joy to many other children. But its legacy remains in a neighborhood where families can live without fear of harassment over ridiculous violations, where kids can be kids, where home truly means a place of safety and freedom. And if I ever get another orange envelope in the mail, well, I know a really good lawyer.